Hello, everyone, and welcome to this presentation of the Beverly Hills Bar Association, Contract Drafting, Protecting IP in AI Deployment and Development. And we're very fortunate, and I'm delighted to introduce our speaker, Mr. Matthew Cole. Matt Cole represents clients in commercial litigation, intellectual property matters, and with data privacy issues. His experience with intellectual property matters includes claims for the misappropriation of trade secrets, trademark infringement, false advertising, the sale of counterfeit goods, and cases involving a variety of patent issues. In addition, Matt counsels companies that develop and use artificial intelligence on AI governance and strategy, intellectual property, data privacy, and regulatory and compliance issues. He writes regularly and is a frequent speaker and panelist on AI, especially as related to intellectual property, data privacy, and corporate policies on the use and management of AI in the workplace. Relying on his over 2 decades of experience as a litigator, Matt drafts and negotiates agreements and licenses for businesses with a focus on protecting intellectual property and proprietary technologies. Also, Matt helps companies develop and implement data privacy programs and is IAPP CIPM certified. And now let's get started.
All right, Adrian, thank you very much. I'm Matt Cole. I am a partner in Saul Ewing's Baltimore office. I lead our firm's AI team, and I'm really excited to be giving this presentation today. IP issues in AI use and AI contracting are really glitchy, important issues, and depending on whether you are signing an agreement for use, purely for use of AI within your organization, or some kind of development agreement, developing your own system, or buying a system and building on top of it, the contractual provisions have different nuances to them related to intellectual property issues. And so we're going to dive into those throughout this presentation. So if we could go to the next slide, and we'd like to just give an overview of today's agenda. So we're going to start off with a little background on some of the AI terminology, with a focus on generative AI as opposed to other types of AI, and then a brief discussion about how some of the different technological aspects can influence the IP decisions and strategy when negotiating an AI agreement. We're going to look at some of the current law and guidances from the Copyright Office and the PTO on IP protection and AI use, and how that will also influence contract negotiation and AI usage with respect to IP. We're going to look at some governance considerations, because really I think the best way to frame this out is to think about things in the right order, understanding your use case, get your governance in place, and then your IP strategy and contracting strategy should flow from that. And then we're going to do a deep dive into into the key terms of many AI software agreements that relate to IP. And then if there's any time, I will answer some of the questions that the attendees put into the Q&A. So why don't we jump right in and go to the next slide, which is just an intro slide. And if you could go to the next slide after that, we'll start talking about AI or Gen AI, and some of the IP issues that play here. So really, artificial intelligence is a computer system, a software system that can mimic human reasoning in some respect, whether it's uh, identifying patterns in large volumes of data, making decisions, making recommendations. Um, the challenge though is there's no universally accepted definition of AI. State statutes will often define AI differently, and even statutes within one state or regulations within one state may define AI differently. Often it's defined very broadly, and how an organization defines AI in its agreement can really influence some of the IP terms. Because there's now AI aspects into a variety of different kinds of software, and the consequences of broad or blanket provisions relating to AI can have consequences or unintended consequences, for instance, at the end of an agreement when there are data deletion obligations. So we're going to talk about Gen AI, and everyone's probably familiar with large language models. But the key is the nature in which they work and how that impacts intellectual property ownership. And so, unlike traditional software, which is deterministic, which means that if you put in the same input, you're bound to get the same output every time, right? Unless there's some kind of error. Large language models, Gen AI systems are probabilistic, which means that they are based on probabilities, and you're not always necessarily going to get the same output every time, even in response to the same prompt, because the AI system is developed it doesn't know anything. It doesn't have quote unquote knowledge or a memory, although it has that in some sense. But an AI system, an LL system, is designed to pick the next word in a sequence based on the probabilities that it's been trained on. So it's probabilistic, and your output is going to vary depending on different things, such as the quality of the training data, the nature of the prompt, and is the system really an enterprise system? How has it been trained, or is it a custom system built for a specific department or use case? And as part of the LLMs, I have various architecture that include the algorithm. Algorithms are not a concept exclusive to AI. It's really a set of rules designed to solve a problem, right? Maybe if condition X exists, then Y happens. Or that's an example of an algorithm. The AI model architecture also includes the training data. It has the large corpus of information that the system is trained on to give it its knowledge base, to help it get language fluency and understand what should be that next word in a sequence in response to a user's prompt. And then the last piece that we're going to talk about are the weights, which are the connections, the internal connections within the neural network that drives the strength of the response between the information in the prompt and what output should look like. And so all of these various things, depending on the type of your AI agreement, the algorithms, the training data, the weights, those could be different. Those are types of intellectual property. And depending on whether you're developing them yourself in conjunction with a developer, your agreement will call out who owns various parts of the AI model, as well as the inputs and the outputs. And so let's go to the next slide, please. And because we're going to talk a little bit today about development projects, or AI development projects, I'm going to add some more terms here. You probably have seen agentic AI. It's a very common term, right? Every company wants to sort of adopt or use AI agents. Not many really understand what the difference is or the import is of an AI agent, how that's different from a typical LLM, but that can also influence intellectual property decisions. And so I think of an AI agent as being different from an LLM in one major respect, right? When you have your conversation with your LLM, you put your prompt in, you hit enter, and you get output, right? That's the end of the AI system's task, as opposed to an agent. And I characterize an agent by using the acronym ORAL, or ORAEL. So unlike an LLM, an AI agent is designed to observe, reason on the observations that it makes in this environment, act upon those observations, and then do it again, right? Loop, an execution loop, perform that task again until the agent believes that it has met or satisfied the user's request, perform the task, etc. So that's a key distinction between an LLM like ChatGPT or Claude, right? They're just going to respond to your prompt, give you the information, that's the end. Whereas the agent has the ability to reason, go outside itself, and continue to do the task over and over until it believes it has satisfactorily completed the task. And another key distinction is connectors, or MCP. MCP stands for Model Context Protocol. And that's sort of an industry standard way for an LLM to connect externally, access external databases or data outside of its own training data. And that could be company databases, it could be the internet, and it allows AI systems to use tools and communicate externally, which of course can influence intellectual property if there's an unintended data leak, or if the AI agent grabs some third-party IP and incorporates it into your output. And so we're going to talk about why indemnity is such an important term when using very sophisticated AI systems, especially agentic AI systems. RAG, or retrieval augmented generation, is another type of AI system that many companies are using or developing internally. If you think of a RAG system, a chatbot is a really good example. A chatbot that is curated or trained on a subset of information. I think of a RAG system as a library or a pre-selected universe of data that you give a pipeline to the LLM, and when you put your prompt into the LLM will access the RAG database for the information to influence its answer, to generate the output. And there are IP implications there because RAG databases are especially curated with pre-selected training data for a very specific purpose. And it could be a general purpose like helping employees answer questions, but it could also be for innovation, competitor intelligence, market assessment, identifying gaps in patents, etc. And the last type of AI we'd probably talk about today is a fine-tuned model, and that's a customized model, a custom trained model, where you take a general foundation LLM and you retrain it or you fine-tune it into a smaller model that uses a smaller set of pre-selected information. So it's different than a RAG database. A fine-tuned model is typically used for a very specific use case and can have departmental or employee or domain specific information in it. And fine-tuned models and RAG models are important when they have important IP implications when a company is developing its own AI systems in-house or taking a third-party enterprise system and building on top of it to develop its own custom tools. Next slide, please. So now we're going to talk a little bit about what the landscape of IP protection and AI in the US. So let's start with some general overview of the copyright and patent boundaries on the next slide, please. So it's pretty clear that output generated exclusively by AI cannot be either patented or copyrighted. Both the US Copyright Office and the PTO, as well as federal courts, have already given us their viewpoint on this. Right? They read the Patent Act and the Copyright Act very literally, both talk about the requirement for an inventor, an author, a human being. And so if you're using AI to innovate, or if you're a content creator, we really have to understand the IP implications that third parties, right, have the ability to use the information, to use your marketing materials, to use your innovation that is exclusively generated by AI. And so when you're developing your AI strategy, you really have to think about what type of output we're going to create. How do we protect it, right? What's our IP strategy? And how do we use the contract to help us get to yes when the law otherwise does not automatically give us the type of protections we would have if there was a human inventor or a human author rather than a automated or artificial one. And so the goal is to get your counterparty, who is going to be probably the AI vendor, right, or an AI developer helping you develop your own system, to agree to give you ownership of the output, the IP, through the contract. All right, next slide, please. And so just doing a little bit of a deeper dive into the copyright and patent issues, exclusively generated information by AI cannot be copyrighted, but information that a human has significant or substantial control over the expressive process can be copyrighted. So if you are a publishing house, or you work with authors, or you create content, for schools or for trainings, and you're using AI and you want to protect that information, you really want to understand or have, what you need to do to get how much human involvement is enough, right? And so it's pretty clear that prompt engineering is insufficient. Your copyright office has told us even if you revise a prompt repeatedly, that's not going to be enough. The AI generated output is still going to be controlled, quote unquote, by the AI. And so the Copyright Office has given 3 examples of how an individual or a human author can establish or demonstrate significant human control over the expression, the creative expression, by doing certain things. So the selection and arrangement of various aspects of the work. For instance, moving the graphical arrangement here, putting the words here, etc. So there may be some creativity in the selection and arrangement of the elements of a work, significant modification to AI generated output, and then very expressive inputs. And so the Copyrights Office's guidance also applies to derivative works, and the Copyright Office has been very clear that authors or applicants must disclose their AI use in copyright applications. And there have even been instances where the Copyright Office is using its investigative abilities to go and look on social media to see if applicants are actually disclosing AI use and honestly and accurately disclosing their AI use. So let's go to the next slide, please, and talk a little bit. We're going to talk now about fair use because this is a consideration when you are signing up or using an AI system, signing a license for an AI system or developing it, and there are potential claims for infringement that could be leveled against you if, for instance, a third party's copyrighted information ends up in your output. And so you're probably familiar with the fact that there's dozens of lawsuits that have been brought against LLM providers in which the primary claim is copyright infringement. And the copyright infringement is really twofold. It's copyright infringement by the LLM developers using the plaintiff's data for training the models, and then copyright infringement for protected information ending up in output that's generated by the AI systems that may be used by third parties. And so last year, the courts out in California in two cases handled or issued rulings on one aspect of the fair use defense, the aspect about whether train AI model training is a fair use. And in fact, both courts found that using books to train AI models is transformative. It does qualify as fair use, right? The AI isn't using the books to generate existing copies or to distribute, exacts of the originals, but using it to break it down and turning it into numbers, to identify patterns, to generate new text, to create completely new output. And so the course saw that as transformative, which is one of the most important and heavily weighted fair use elements. By contrast, the court found that maintaining a library of unauthorized information, a shadow library, keeping it, acquiring it without permission, right, that constitutes infringement. So the court is drawing a very broad, a very, sharp distinction between the act of training and the copyright implications around that versus the act of collecting and maintaining information without authorization that will ultimately or may ultimately be used for training, which is a no-no and can constitute infringement, the collection and maintenance. And so as you're thinking through your IP strategy, your AI strategy, right, and you're going to really focus on indemnity, the key question is, can your output include a third party's copyrighted information? All right, next slide, please. And there's a similar theme with patentability, although the PTO has changed its approach a little bit. But initially, it's very similar to what the Copyright Office said. It was, an inventor must be human. Innovations, inventions, if you will, generated exclusively by AI are not patentable. The same inventor-human requirement under the Patent Act exists, a corollary to the Copyright Act. And in February of 2024, the PTO issued inventorship guidance for AI-assisted inventions. They use the same language that you've historically seen, right? For there to be inventorship, there must be a significant contribution of a human. And in this guidance, the PTO measured the human contribution. The test was, how do you measure the human contributions against the Gen AI output, right? How do you, as a applicant and inventor, really demonstrate to the PTO that your involvement in the inventive process was significant enough that you should get credit as an inventor of that invention? So next slide, please. And so late last year, the PTO issued revised inventorship guidance for AI-assisted inventions, recognizing that AI is going to be used quite a bit and has been actually for innovation. And, inventors need a way to protect their inventions, their innovations, right? And so the AI must be viewed, the PTO now views AI as an instrument and legally equivalent to laboratory equipment, specialized software, or a database, right? Is there to assist the inventor, not replace the inventor. There's no higher conception test for AI-assisted patents, but the human must really have the definite and permanent idea of the claimed invention and used AI to solve that problem, but doing it in a very specific and granular way. Simply writing a prompt that says, "Hey AI, here's a disease. How do I fix this?" Right? That's clearly not going to be enough. But if you can demonstrate and document a specific hypothesis, the ground rules and the parameters you gave the AI system, whether it's uploading documents, proprietary information, other patents, research papers, product manuals, whatever it is, and then lay out in as much granular detail as you can the problem, what you want the AI system to do, and demonstrate that you made a substantial contribution to innovation throughout the entire way. That is going to increase the likelihood of the PTO granting you a patent for using AI to assist with the innovative process, not to overtake or be solely responsible for the inventive process. And it's the same story with obviously creative process and obtaining copyrights. So next slide, please. So where does that leave us, right? That leaves us with trade secrets and AI, because for trade secrets, they're very flexible. You don't have that human involvement requirement. There's no inventorship requirement. Trade secrets can be any information, right? The DTSA, the Defend Trade Secrets Act, and I believe all the state corollaries under the UTSA, the Uniform Trade Secrets Act, uses the very broad term information that can qualify as a trade secret so long as it meets the specific criteria. But thinking about AI and trade secrets, right? If you are signing an agreement or deploying AI, you're going to want to use most likely AI for innovation, but you're also going to be most likely putting proprietary, sensitive business information, marketing information, customer information, pricing information, et cetera, possibly even formulas into the AI system. So you want to make sure that it's secure and that your agreements clearly spell out who owns what in the chain of submitting the prompt and then generating the output, but as well as using the output and any insights derived from that output. And then thinking about it as well, if you are developing an AI system, customizing an AI system, you're going to want to consider the AI system that you've developed that's been customized for you, for which you've submitted your proprietary information that you've helped train. Consider that your trade secret, your proprietary information, your IP. And then we're going to talk about too through how to protect against through the contract AI leading to the loss of trade secret protection, either through some unintentional data leakage, through data training by a third party, or even through a third party retaining your information indefinitely that gives a defendant, for instance, an argument that the plaintiff did not take reasonable measures to protect their trade secrets. So next slide, please. And of course, with everything else in AI and IP, there's a countertension even with training data, and California is leading the way on this tension here, right? If we want to keep as much as we can secret versus the trend towards AI transparency and disclosure. So just quickly, earlier this year, California statute AB 2013 went into effect. It's the training data disclosure statute. It applies retroactively to any models released on or after January 1, 2022. So that was designed to capture all the frontier LLMs because ChatGPT was commercially released November 30th of 2022. It applies not just to, well, it applies to developers, but broadly defines developers to be more than just the developers of the large foundation models, the Claudes, the ChatGPTs, the Gemini. So it's more than just Google or Anthropic or OpenAI, right? This law covers companies that fine-tune AI models and or retrains AI systems for their internal uses. And the obligation is the publication of a high-level summary of sources, owners, purposes, IP rights, and I believe there's about 12 categories of data that the AI system developer has to publish. So, as you're thinking through your IP strategy and your contract strategy, right, you're going to have to think, okay, we want to develop our own AI system, but, on the other hand, what are our disclosure obligations and how do we maintain this information as a trade secret? New York has a very similar statute that just went into effect. Other states, I believe, have Proposed legislation, Maryland, where I am, has a bill that's similar to California AB 2013. So really the takeaway from these first few slides is that signing an agreement for an AI system or to develop an AI system, the IP implications are significant. So you really have to think about this, from the inception of the process, not when you are negotiating the deal, but you really want to identify the use cases, understand the IP implications through ownership, through liability, risk exposure, and the potential for loss of IP or third-party use of what you would consider your IP, because it is very nuanced when using an AI system. And so let's talk a little bit now, if you would, next slide, about how to develop that front-end AI strategy and the IP implications. And so let's go to the next slide, which really breaks down at a high level the divide between some of the IP considerations for an agreement to deploy AI, right, which is simply signing a license, an enterprise agreement to use Claude at your company versus an AI development agreement, which can be something, developing a RAG system, fine-tuning a model, maybe making a small language model, or taking some existing system and customizing it for your use. So here's some of the key considerations, right? For the IP ownership and focus for the deployment agreement, it is now becoming pretty much standard. There are very few standard terms in AI software agreements, but ownership of inputs and outputs by the customer is one of them, especially in AI deployment agreements. Although from time to time, I do see agreements in which the AI vendor does try to retain ownership of the AI output, and it does become a significant negotiating point. In contrast with AI deployment agreements, where you also have to consider the allocation of the pre-existing IP, the customer's IP that you're using for fine-tuning or model development, versus the ownership of the new IP, the foreground IP, right? The output, what's going to go in it, what sources is it going to pull from, who's going to claim ownership, and who has licenses over all the information throughout the entire flow of data. Another consideration, right, not necessarily legal, but a pseudo business legal consideration is the customization complexity. So if it's just an AI deployment agreement, you're not customizing it per se, you're not fine-tuning it or having it sync up to a RAG model necessarily. You may, develop some custom workflows, but that's a little bit different. You're really just using an off-the-shelf AI model, and it's learning, so your patterns, and you're going to use it for your specific tasks, but it's not a true customization like a development project, like fine tuning or a RAG database, in which you're going to have other IP ownership considerations and other considerations at the termination of the agreement. I want to talk about that, how to really set this up so that way when the relationship ends, you don't have any questions about who owns what, who gets to keep my IP, how can it be used, and what third parties will have access to it, and how long will it be retained. These are all the key questions to consider as you're thinking through an AI strategy and the IP questions. And as I mentioned, termination, what's your off-ramping priority, right? If it's a deployment agreement, you just want to make sure that vendor does not keep your customer data or keeps very little of it, or just what they need for specific purposes, to comply with their data privacy obligations or for fraud or abuse monitoring, as opposed to a development agreement where a custom model has been developed or a database has developed, and if it's most likely going to have customer data in it, and you're going to want to either claim ownership of it, or if you can't get that, get some verified destruction of it, so no third party gets access to your information. All right, so next slide, please. So here's some of the things to think about when you are formulating your AI strategy, some of the key IP questions, right? Obviously, you want to think about the IP issues and risks when developing the use case for the AI system. And so those are infringement, ownership, and use of IP, as well as validity, right? Which we talked about if you are using AI to create innovations that are potentially patentable, or you would like to protect them through copyright protection. Because AI systems use a variety of data, different for a development agreement where you may be licensing in third-party data, you may be using publicly available data, you may be using your data or some combination of all three. You really want to understand the ownership and lineage of the data sets before using it to generate output or developing a custom system. You don't want to run into any licensing issues. You don't want to walk into any claims for infringement or right. So you have to really understand how the model's trained. If you're developing it with a partner, what rights they have, permissions they have, and just understanding the data flow from design and development through actual use and commercialization if you are using a system externally, if you're a vendor yourself developing an AI system. As I mentioned, ownership rights, usage rights, and deletion are key questions, key issues to consider as part of the AI system lifecycle, but you really want to hash those out in advance and go into the negotiation with your counterparty, with a plan, but also with some backup, fallback, positions, because vendors are very protective of data and AI negotiating AI software agreements continues to be a AI vendor data grab, and we're going to talk about that in a few minutes, the various categories of data and how complicated it is getting when it comes to protecting IP in AI agreements. And just another consideration, right? You can permissibly reverse engineer a competitor's trade secrets. Using AI to do that is a great use case. And so, if what are the considerations there when doing that, right? You want to make sure you're not walking into any trade secret claims for improper means. And thinking about really how AI can benefit you if you are going to consider it a trade secret, use it for trade secret purposes, use it for innovation, and maybe not necessarily for patenting inventions. Using AI to reverse engineer competitors' trade secrets is an increasingly popular use case among companies that have significant R&D budgets and departments. And so thinking about these questions, these are some of the key questions that will influence your negotiation strategy as you get into the weeds of the back and forth with your counterparty on the various provisions, but especially the intellectual property provisions. So let's jump ahead now to the next slide. And so we're going to look at some of the key contractual sections and provisions. And from my perspective, it really starts with the definitions in an AI agreement. Like traditional SaaS and software agreements have a lot of definitions, but AI agreements take this to a whole new level, especially with the various data categories at play. So we're going to start with the three most basic ones for inputs. That's the information that the user puts into the prompt, typically in text form, though LLMs presently allow for attachments to be uploaded. So that can mean like your proprietary documents, your R&D meeting notes, photos of your factory, right? Anything else that you have obtained. And it can even be publicly available information organized or compiled in a unique way, right? And the AI systems are not just able to see the prompt and the attachment, but modern LLMs can also review the metadata within documents. And so that's an important consideration if, for instance, you have track changes, comments in a Word file, other metadata associated with attachments that you are uploading to an LLM, you really want to have a broad definition of inputs to include the text-based prompt, the attachment, and if you can, the metadata found in the attachments. Because that's your information. The inputs are going to be owned by the customer. So you want to make sure that all the information that goes into the LLM remains your proprietary information. And you'll notice in the definition of inputs, I have submitted to or accessed by the services. And access, right, includes the new reality of AI systems communicating with API feeds or data pipelines through a RAG database or MCP connectors, right? It can access other databases. And so it's more now than just submitting a prompt. Inputs have to be comprehensive and include all the information accessed by the AI system to generate the output. And so, here's a good definition of output, right? It really is just the responses generated by the services, which is the AI platform, based on the inputs and customer data, right? So if you are, for instance, developing an AI system, if you are providing a RAG database, if you're giving it access to some other information beyond the input, your definition of customer data should capture that and the output should cover both the inputs and any other proprietary information the AI system used to generate a response that the customer supplied. And in addition to that, it's not just the output itself, but it's the summaries, the synthesized takeaways, and all the insights derived from the outputs, right, that you want to own as your proprietary information, as your trade secrets as well. So don't just limit it when you're defining output in the agreement to I hit X, hit enter, I put an X, and I get Y. No, it's broader than that. It's all the insights derived from the outputs that you want to claim as well. And there's a tension there because vendors want to own as much data as possible, and specifically various categories of derived data or data they consider the byproduct of AI use, things like performance data, usage data, some types of metadata. So really having specific carefully drafted definitions in your agreement, your AI software agreement is key to protect the IP that's pre-existing and any IP that is generated through your use of the AI system. And then customer data, which is a term you often see in all manner of AI software services agreements, right? So it could be all data content, blah, 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 supplied by or on behalf of the customer to the AI vendor and generated through the customer's use of the services, right? So we're capturing output, everything we've given the vendor to create the AI system for our purposes or to generate, or when output is generated using our data. And, it's very common now for vendors, software vendors to add AI features to existing software systems. And if they do that, you really should. And then sometimes they'll provide you with an AI addendum. I think if you're a customer, is a best practice to have an AI addendum at the ready for when this happens and be proactive and go to your vendor and say, well, now we need to negotiate on these AI terms because for the reasons we talked about, the probabilistic nature, the different kinds of output, you really want to drill down on IP ownership, and an underlying traditional SaaS agreement really isn't built to deal with innovation when using AI. So you should supplement your existing SaaS or services agreement or master services agreement with an AI addendum that addresses these issues. And of course, it's important to make sure that customer data as defined in the AI addendum is consistent with how customer data is defined in the underlying software agreement. Next slide, please. And so here's the IP ownership framework that really has taken place or is starting to take shape through negotiation, right? Customers retain all rights and input. That's a very non-controversial proposition these days in AI negotiation land, although there is very little that's not controversial, that's not contested. In a deployment arrangement, the vendor will retain ownership of the model of the services, right? But not the results of its use, not the output. It has become standard for customers to own the output, recognizing that the agreement is going to say it may not be copyrightable, it's probably not patentable. Therefore, right, your contract should not just say, should really lay out in clear terms that the customer, to the extent permitted by applicable law, you're seeing that phrase a lot added by the vendor to protect themselves, and it's completely understandable for the reasons we discussed earlier, but the customer owns all rights in inputs, outputs, right? So you get not just the results, but you also get the derived insights, the key takeaways, and I think it's the best practice to not just declare ownership, but have the vendor provide an explicit assignment of all rights in the output to the customer. That also is not controversial. And if you're getting pushback from your vendor, all you have to do is point them to OpenAI's enterprise terms of service or Anthropic's enterprise terms of service. And all the large LLM providers, they all, in their standard terms, assign any rights that they may have in the output to the customer. So there's your framework, right? You own the input as a customer, all the data supplied, you own the output. And if it's a deployment agreement, the vendor retains ownership of the model. We're going to talk about how that differs in a development arrangement. So next slide, please. So one thing you hear quite a bit about is the risk of a third party, an AI vendor or some other third party, a sub-processor, right, training on your data. So really what that means is that these AI systems are designed to continuously learn, be updated based on the information that people submit in prompts. And For enterprise agreements, it has become relatively standard, I think, for vendors to promise to agree not to train on customer data, not to train on inputs, or not to train on outputs. But there's always a nuance there, and there's always a little bit of a pitfall, which is while the vendor, on the one hand, promises not to train on your data, it will often include a provision that will, at the same time, allow it to use your data to improve the services. So when you see that, you of course are thinking that this is inconsistent. And so you have to go back to the vendor and say, really, what does this mean? Because improve is vague. Training is a form of improving, right? Because it makes the system better. It's got more data, more current data. Better data is better suited to give the user the response, the output it is after. And so you really have to drill down with the vendor what improve means, strike this term, and really specify how the vendor can use your data, if at all, with regard to the services. So you can do that by allowing the vendor, for instance, to use certain categories of data for fraud monitoring, abuse monitoring, right? If you have to comply with certain privacy obligations, you can agree to all that, but specificity is the key here. And improving the services is really just a backdoor to letting the vendor train on your information. And so when you're defining training, many agreements do not have a definition of training. I think it's a good practice to include it. And here are different types of training. You can even use this as a pretty robust definition. It captures the training of the model at various stages, initial development, fine tuning, continued training, etc. And it has a pretty, good litany of what might be considered training, so development, improve, right? You really want to take the ability to improve the services and proprietary information out of the vendor's hands. Um, and so here's a trap, right? Here's the kind of provision that you might see in an agreement that I was just talking about, where a vendor is going to say, well, look, we're going to use your data to improve our services, but it's going to be aggregated, it's going to be anonymized. Those terms really apply to personal information, to protection of people's privacy rights. But when you see that, you got to think to yourself, how does this help me? How does this protect my IP? And, I'm not so sure that anonymizing the customer data is going to give me comfort that the vendor is going to use it to improve their services, not just from a risk exposure uh, reason, but AI systems have the ability. They're very good at understanding patterns, and they can re-identify individuals when using data sets by looking at user behavior. It's called the mosaic effect. So there's always a risk when allowing vendors to use your data, even if they tell you, don't worry about it, it's anonymized, it complies with the privacy statutes. There are still potentially implications out there about what the AI system can recreate, not just from a privacy perspective, but from an IP perspective. It may see, for instance, that you're interested in a customer market in this geography at this price point or this type of customer, and it can regenerate that kind of information, even though it's been anonymized. So watch out for these traps where vendors really want to grab your data. So here's an example of a good provision in my opinion. It's very broad. It prohibits the vendor from training on your data. It prohibits vendors, third parties, or sub-processors from training on your data. So, right, a lot of the agreements will say vendor agrees not to allow a third party to train on your data. You really have to be careful and look at it. Is the vendor going to be training on my data? And are the vendor's contract partners going to be training on my data? And so there is a lot of tension in the marketplace because many AI providers are middlemen, right? They're not selling you the Anthropic, the Claude, or the ChatGPT, but they're building their system on top of it. So when you're negotiating with the smaller AI providers rather than the larger developers, they may be contractually constrained as to what they can agree with you, as to how they can and cannot use your data. They may have certain obligations that flow upstream to their contract partner, right, who is most likely the AI developer that could tie their hands in the terms that they reach with you. So that's just a consideration. Although I have found that negotiating AI agreements with some of the smaller AI providers, you have better luck in reaching, getting to yes and getting concessions from the smaller providers, whereas the large LLM providers, more and more throughout 2026, has been a sort of take it or leave it kind of a story. They're generally unwilling and not very flexible on many terms, unless you have a large account, compelling case, right? A specific risk and compliance obligation. So that's sort of, what's playing out, but, thinking about not just the middleman, but the people at the top of the food chain, so to speak, and the contractual restrictions may flow down to what you're able to accomplish through negotiation, with an AI vendor. And so, next slide, please. As I mentioned this before, right, AI can learn from patterns in data, not just the information explicitly in the content. So AI vendors want as much data as possible because they find value in it to improve their services, to create new models. And so AI agreements have multiple data categories that you typically don't see or may not see in standard agreements. So there's AI usage of data, there's AI performance data. You may see terms like that in your standard SaaS agreements that are defined, metadata. And so when you're negotiating the agreement, you really want to make sure that customer information doesn't appear, right? Your proprietary information isn't going to show up in usage data, performance data, or metadata that's the output, the byproduct of use. Because if it is, you don't want to give that away to the vendor to claim ownership of. You want to minimize however they can use it. You certainly don't want them training on it. So you really have to understand sort of the data flow. If the usage data and performance data doesn't present an IP risk, right? Or it's a very low risk, then that's a different story. But again, like I will emphasize, thinking about your IP strategy and understanding the technology and the use case is going to really influence how you negotiate these agreements, how you define certain terms, and what rights you're willing to give your AI vendor. Next slide, please. And so let's look now for a few slides at the development contract and how that adds a level of complexity and requires some additional definitions. And so, right, you're customizing or creating a new model for you in conjunction with the vendor. And so, customer trained model, you want to define that term in the AI agreement, right? And distinguish it from the LLM, the services that you're going to be using. It may be built on top of it. It may work in conjunction with it, right? To make it what's going to typically happen is your custom trained model or your database is going to rely on the LLM for the language fluency to generate the output, and your contract is to really distinguish between that model and any customer trained model from a data provision standpoint, what data are you providing, but also ownership of that customer trained model. And it can take three paths. Customer ownership, customer owns a customized model, the data set and the weights, right? If you're developing a RAG database, you're developing some kind of fine-tuned model, that's really what you're shooting for. Ownership of the model. I've seen it happen. Vendors are willing to do that. It just depends on your vendor. So it really is a case-by-case assessment. I mean, I said earlier that it's a take it or leave it approach with a lot of AI vendors. By contrast, there are so many companies out there now offering AI products. If you don't have a good feeling or if you're not getting any traction, with your counterparty that you're negotiating with on provisions that make sense, that advance your organization's business case, find somebody else. The second path is that the developer owns the modifications to the model, but gives the customer an exclusive license to use the custom trained model. That presents a little bit more of a risk to the customer. And then, of course, there's joint ownership of the custom trained model, which I do not recommend because you want to have a clear understanding of who owns the data, how it can be commercialized, and what happens to it after the relationship ends. And joint ownership can really cloudy and can muddy those waters quite a bit and give a third party control of your IP that you never intended to when you were going into the considering AI use within your organization. And so now let's go to the next slide, and we're going to look at some additional terms to include in your AI contract for when you're developing an AI system, right? So AI systems are typically a multi-tenant architecture, all the enterprise versions that you're using of the LLMs, It's not just your company that's in that data environment. There's, hundreds, if not thousands, right, of other users using it at the same time. And so when you're developing an AI system for your organization, you want to mandate a siloed architecture that has your data, your customer data, your inputs, and any outputs that are derived exclusively from customer data, right? Siloed, segregated, so that third parties can't access them. They can't, see them. They can't, the output remains yours and it's only accessible to your team, your employees, or your contract partners, your consultants, right? If you're hiring third parties for some kind of R&D project. And of course, you want secure licenses for the use of third party or developer-owned data sets that might be commingled during output generation. So, one example is if you're developing a RAG database, you may include in it your own proprietary information. You may include in it publicly available information that you pull off the internet, maybe patents, maybe statutes, maybe regulations. And then you may also be licensing third-party data for use in your RAG database, and it may be commingled when output is generated. So you really want to lay out and have your contract speak to, who owns all the different categories of data, and if it is third-party data, as being you're going to license it yourself, or the vendor or the developer is going to license it for you and have rights to allow you to use it. You're really going to want to get some reps and warranties in the agreement that the vendor has those rights. A development well, deployment agreements, warn customers that their output may not be unique or may contain information from the internet, right? That's a little bit different from a development agreement where you can technologically actually set it up so that the output only has, your information or information that you curated or have some right to, as opposed to some unknown third party, which may influence or may negatively impact your ability to copyright that information or, or whatever, patent it or protect it. And basically, in majority of disclaimers that I see in deployment agreements, the AI vendor tells you this, that your output is not going to be may not be unique, may contain third-party information, may resemble stuff on the internet, and it's basically telling you like, hey, you are not going to be able to copyright this stuff most likely. So that's there are definitely some keys to a development agreement because you're really going to own the process, own the inputs, own the outputs, own the model. It's just a much more labor intensive and resource intensive endeavor. And so let's go to the next slide, please. And so here are some other terms that relate to, right, the IP implications of the agreement, your reps, your warranties, and your indemnity. And I will say this, AI vendors are disclaiming everything. They're not standing behind a whole heck of a lot. They're not standing behind necessarily the quality of their output. So you really have to fight hard to get the protections you need to limit your risk and to protect your IP. And so you want to get some reps and warranties, right? The first two are pretty important. Get a warranty from the vendor that the model was not trained on sensitive or unauthorized data sets. So that could be, information that has third-party copyrighted information in it, third-party IP, of course, data privacy issues. That's a different webinar. So you really want to make sure that the vendor is telling you that they have the rights and the licenses to use the information in the model and for you to use the services to give you some comfort that you're not necessarily going to be sued for some kind of infringement or IP violation, misappropriation of trade secrets, etc. In conjunction with that, it is pretty common to get a IP infringement indemnity. Mostly for the training data. Output's a little harder. However, there are a number of carve-outs that really do limit the value of the indemnity provision. Of course, right, if the customer intentionally infringes a third party's output, a third party IP, the vendor is going to exclude you from the indemnity provision. But similar to what you see in traditional SaaS agreements, there are carve-outs or exceptions to indemnity if the customer modifies the service, combines it with third-party software, third-party API feeds, and that's sort of the point of an AI system is the modifiability of it, developing custom workflows, integrating, other data into it, combining it with other systems. And so by doing that, right, reading the agreement, you are probably losing your IP indemnity protection. So again, the point is, as you're thinking through your IP/AI strategy, you really have to understand what are the consequences down the road if we are combining our system with a third-party software platform, et cetera. Is that going to cause us to lose the limited protections we have? Um, it seems to be that indemnity is taking a shared responsibility or a shared risk model where the vendor is responsible for the AI model and the training data from a liability perspective, and the customer is responsible for the output, right? Vendors will tell you that they disclaim all the output, they take no responsibility, no reliability for it. And in fact, many AI agreements require the customer to have humans review uh, the output before using it. And if you don't, right, if there's a finding in a court case, for instance, that you did not comply with your human in the loop obligations, you're going to lose your IP protection, and you're going to be, there's a risk of infringement claim going to judgment against you. The next slide, please. And so the last two slides are going to focus on what to do, how to set up a good termination or a good walk away from your contract partner. Now, keep in mind, right, the goal of an AI system is integration through workflows across systems. I would not take that relationship lightly. You want to have a long-term relationship with your vendor because it is a real challenge to switch vendors and retrain your people and do all the things you did with data once again. But you also want to make sure that you are protecting your information on the agreement if and when it does end, right? So the typical customer expectation is that all my data will be deleted or returned by the vendor if you allowed the vendor to train on your data. That's not so simple, right? AI models cannot simply unlearn data. It's a big, expensive, and technologically very difficult process, and something a vendor is never going to agree to pull some information out of an AI system's training set. That's why it's really key to have no data training clauses that are very broad and protect you. Um, when you are doing an AI development arrangement, you want to make sure you've defined the custom aspects adequately in the agreement. What is the customer training data, the customer training model, so that way the obligations or to destroy, delete, or continue use of these custom systems are clearly spelled out when the contract ends, right? You may want to push for deletion of the model with a certificate of destruction by the vendor. I think that's getting to be, that's not controversial. Um, and of course, you want to negotiate for automatic exit rights if the model that you're using is found to be infringing or if it fails an audit. And one of the reasons it may fail an audit is, violating IP. Can be very challenging, of course, to audit an AI system. I mean, be careful what you wish for. If I had, 500 megs of data from an AI system, I probably wouldn't know what to do with it. I would need to get an outside expert. But, you still want to push for the protections if something does go wrong. So that way, if there is going to be, the vendor is found to be infringing a plaintiff's copyright, that risk does flow down to you. So you want to get out of that arrangement as quickly as possible, or alternatively, see if the vendor can supply aspects of the model that are not infringing. That is a case-by-case basis. And then we'll go to the next slide, which is sort of some things to think about for information destruction at termination, right? I mean, I don't know how many more times I can say this, but it's really key that vendors want as much of your data for as long as they can keep it for as many different uses as they can. They want to retain embedded data in their systems, and that can lead to risks with trade secret protection. Sometimes vendors will impose an obligation on the customer to send a written deletion request as opposed to automatic deletion at the end of the agreement. So, be wary of those, and you want to have clear destruction protocols that like destruction of servers, erasure of information. So it's very clear as to what the vendor must do when the agreement ends, and of course, verifiable compliance. And let's go to the next slide. And we have a minute for one question. And they are really focused on the really focused on the IP implications. And I will say this, they're talking about some of the copyright cases that came in and questions about human involvement and demonstration of substantial human contributions. And like with anything else in AI governance, AI use cases, documentation is key. You really want to show control of the creative or inventive process from start to finish, especially if you're using a custom AI model to do that. You really want to demonstrate the problem that you identified and how you manage control the AI system to get to the solution. And so next slide. And so that's my presentation. It's been an hour. I want to thank you very much. And if you have any questions after today, feel free to reach out.
This concludes today's presentation. Thank you so much, Matt Cole, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.